Ricomincio. Buongiorno. Buongiorno, sono Andrea Beccalli, faccio parte del comitato di programma di EGF Italia 2021, eh, lavoro per ICANN, ma in questo caso ho il privilegio e il piacere di moderare una discussione che sarà in inglese, ma faccio questa breve introduzione solo in italiano. Questa sessione sulle carte e dichiarazioni dei diritti digitali in Europa. Un tema che ormai credo sia di rilevanza fondamentale per tutti noi come utenti internet, come utenti del ciberspazio globale, ma che purtroppo, a mio avviso, non è così sempre presente nel dibattito quotidiano. Abbiamo visto nella sessione di apertura di ieri, nella sessione di oggi, di questa mattina, sono stati affrontati temi fondamentali per la governance di Internet, però io personalmente non ho sentito parlare ancora di diritti. Questa mattina c'è una sessione molto interessante sulla cyber security, un tema estremamente rilevante con impatti economici eh, molto visibili anche dal punto di vista geostrategico, però anche lì a discussione sui diritti non ne ho
Buongiorno,
sentito
salve.
parlare. Ok, vedo che ci sono tutti i nostri panelist di oggi e parlerò adesso in inglese. I'll switch to English. So, good morning, everyone. Thank you for joining to this session. I see people keep joining in. Welcome to this edition of the Italian IGF 2021. We have a very distinguished panel today with representatives both from the European institution and from three different European countries on a topic that is central to our daily digital lives and even more going forward. So we just learned that soon we'll be living into the metaverse. So even the discussion about cyberspace is outdated. So, and I personally hope, and this will be also the goal of this discussion, that we will, whatever new space we will be living, uh, our fundamental rights and human rights will be rooted and defended and protected in this space, and that will also keep being implemented and evolved and developed with new rights to be protected and new ways to enforce and protect them. So, as I said, we have a very distinguished series of panelists. We have starting from my tiles on the right. I have Ana Festas Enriquez from Portugal. She's the no, Anna. Now I just lost your wait. I just had it here. Your complete title. So
If you
you
want.
are the advisor to the Portuguese Secretary of State for the Digital Transition. So I got it right. And Anna, she will tell us more about how the not so far Portuguese presidency put the digital of the European Council put the digital rights at the center of the debate and led into the discussion of the Lisbon Declaration more than the discussion and how this became like a central pillars also of the new plan for Europe, the Europe 2030. So it gives us an interesting perspective, and also if she can mention something about how the Portuguese government and actually Parliament approved a digital charter of rights just this summer. Then we will go to, following to Anna, I see Sébastien Bachelet, a longtime friend, long-time friend from from the internet governance space, but he's not only active in the internet governance, let's say in the technical field, but also as a very active member of the ISOC France chapter. And he will tell us a bit more about the French experience, the discussion in France about digital rights. I think has been very active and probably one of the most active in Europe. And until it turned into a tentative to bring the digital rights within the constitution, I think was a very high hoped and high level initiative, but it didn't go through completely, and but the debate didn't finish there, so we'll learn more about that. We will have then Gemma Carolillo, the deputy head of the Next Generation Internet Unit at DG Connect from the European Union. And of course, Gemma will complement what Anna will bring us with the Lisbon Declaration, but more to look into the future. Now, what is the plan of the European Union? What the European Union is working on? What do we want to achieve? What is the impact for the 27 countries and the citizens of those countries? And how we can participate and follow into this process. Then we have Laura, last on the tiles, but not of course not last in our panel. Laura Dominici is the senior policy advisor for digital society in the Spanish in Spain. So she works for the Spanish ministry, and also Spain has been working on a charter on digital rights, which I think was also a few weeks apart from the initiative that Portugal last summer approved. So it's a charter, it's not a declaration, but it still has an important impact. So we want to learn and hear more about that. So we see these movements in Europe coming from the south of Europe and towards constitutionalization on the digital space of the fundamental rights. So I'll move now from this introduction to ask Laura to share the experience in Spain. How did it started? What is the charter centering on? Of course, digital rights, but from which angle? What is the general impact and how the public in Spain has been reacting to that? So, Laura, I'll let you the floor, and then we will continue the discussion. Thank you.
Buongiorno, grazie mille, Andrea. Thank you very much to you all. And first of all, I would like to thank IGF Italy for organizing this interesting meeting, this interesting session, which is a very great opportunity to discuss the state of the art of the protection of human rights in the internet, and to get to know the experience of other countries and the EU in making internet a safer place for all. So I wanted to briefly take the floor to share with you all our experience with regard to the Charter of Digital Rights recently adopted here in Spain. We live in a digital society, and we increasingly depend on digital devices, digital services, and this context gives rise to new scenarios and conflicts that should be addressed by adapting existing rights and systematically interpreting the law in order to protect the constitutional values and the legal certainty of citizens, economic operators, and public administrations. Concerning how this all started in Spain, our charter is based on the great progress already made in Spain in recognizing digital rights, particularly thanks to the passing of the Organic Law for the Protection of Personal Data and Digital Rights in 2018. But with the adoption of this charter, Spain meets one of the milestones set out in our Recovery, Transformation and Resilience Plan, and it is also one of the 10 objectives set out in the Spanish Digital Agenda 2025. As regards the Charter itself, this new document was officially presented by the President of the Spanish government in July this year. And the text aims to recognize the very new challenges in implementing and interpreting the adaptation and adapting the digital rights to the digital environment and the new challenges it poses. And it also aims at suggesting, let's say, principles and policies in this field. The Charter is based on a basic principle. Rights protected offline should be equally protected online. As regards the context and the content of this Charter, it is structured around 6 thematic pillars, including rights on freedom, equality rights, rights of participation, rights related to the working environment, specific rights in specific environment. And then finally, the Charter includes a specific mention to guarantees, including rights such as the right to administrative and judicial protection and redress in digital environments. As regards its nature, without being binding in nature, the Charter provides a reference framework to ensure citizens' digital rights, and it aims at recognizing the challenges of adapting existing rights to the digital environment. As a result, this Charter contains, as I said, a set of principles and rights to guide future regulatory actions and the development of public policies in this field in order to guarantee the protection of individual and collective rights in the digital scenario. From this point of view, we could say that the text might be defined as a declaration of soft law. And in addition, the Charter aims at contributing to the global reflection and debate on how to ensure and promote digital humanism, and this in cooperation with other countries and with the EU. But if I may say, the real novelty introduced by this Charter resides in its elaboration process, which was a very participatory and inclusive one, and it involved both experts and citizens. So we could say that there is a strong multi-stakeholder component in this Charter. The process was launched more than 1 year ago. That was on June 15th last year, and it was launched by the Minister for Economic Affairs and Digital Transformation, Nadia Calvino. And that day, a group of 18 experts from the field of digital rights was put into place. Its mission was to present a draft version of this Charter, taking into account the existing experience in Spain as well as in other countries. The process took a whole year to come to completion and included 2 open consultations with citizenship. The first one was aimed at gathering opinions on the initiative itself, and the second one was focused on the first draft version of the chapter. Specific meetings were also held with sectoral organizations, including the technology sector, the Advisory Council for Artificial Intelligence in Spain, cultural industries, etc. And the main challenge was to process and translate all these inputs into the text of the Charter. This text was finally adopted on the 13th July this year as an agreement of the Council of Ministers and was publicly presented the day after by the Spanish Prime Minister. And now we are entering the next steps, and and our main goal is to begin dissemination activities, and we are looking forward to further developing the Charter. In this phase, the participation of all public administrations, both at the state and regional level, will be crucial. And of course, we look forward to contribute to the different initiatives and debates like this one. I would like to finish this short intervention encouraging all the participants to further the agenda relating to rights and ethics in the digital transformation in order to make the most of digitalization whilst respecting fundamental rights and freedoms. Thank you very much.
Grazie, Anna. Thank you. So there was a very good overview, and I took some notes. We will leave it for after this round of introduction for some question and answer. But I already noted that at the base of this charter there was this consultation model, this multi-stakeholder bottom-up approach that I think is a thread of all those initiatives. And I want to just change a little bit the order. I want to see if Sebastian would like to make an intervention sharing the experience of the debate in France, because I think it's it's a very interesting experience, as France is leading under many fronts on the concept of digital sovereignty. They expressed the European Commissioner that is dealing with the major legislative initiatives like the DSA, the DMA, and at the national level, the debate is quite active. I remember years ago, the first time that I heard the word Uberisation de la société, the Uberization of society was in France, and it wasn't from an academic. It was on a newspaper that I just found in a kiosk. But yet it didn't achieve the goal that was set. Maybe was it too high, the goal to get into the constitution, to include digital rights into the constitution? Is it too stiff? Is that the best approach? It really goes on the other front from what Laura just presented. They started with a charter, with a bottom-up discussion, and then this will eventually lead into a legislative initiative. So, Sebastian, can you tell us a bit more about what was the debate in 2018, what you learned from that, and what is now?
Thank you very much. I will try my best. Sébastien Bacholet. I'm honorary chair of the ISOC French chapter, but I am also member of the Italian one since long time ago. Even if I can't speak anymore in Italian, I will try to give you some background information. But before going to this part of what was tried to be done within the change of the constitution, or adding a specific chapter about internet rights or digital rights, we came from a long type of discussion. First, I will not say first, but in 2014, the what it's called the State Council, with an independent body, issue a document about fundamental rights and the digital, and it was, I guess, from official body, the first time that it was a so comprehensive document issue at that moment. And then if I take what just Laura said, it's we got a French law, the digital bill, in 2016, and it was really done. At that time, it was the president of the country was François Hollande, and Axel Le Maire was the one in charge of digital within the government. And we know her not just because she was participating and doing that, but she also at that time participate to some ICANN meeting. You may remember, for the one who was there, she was struggling against the way ICANN was dealing with .20 in French and .wine in English, and therefore she participated to some ICANN meetings and some other discussion. But this digital build was built by consultation with citizens over a period of three weeks, and a group was in charge of giving a synthesis of all that, and it's become a law. Therefore, we have nothing in the constitution, but we have a digital bill already accepted in 2016. The idea was in 2018 to have something written at the taking the opportunities that something may change within the constitution, because it's quite complicated to have a change within the French constitution. You need to have 2/3 of the two houses of the parliament to be agreed with, or you need to have a vote, citizen vote, referendum, and that's not very easy. And therefore, there were a lot of discussion about adding a constitutional charter about rights and liberty, about digital, of course. And the deputy, it's not deputy, the parliamentary was Paula Forteza, and she might have been a better speaker today to talk about that, because she was really key in that. But even in the party she was member at that time, they disagree with this proposal. And the one who were in charge of this law is now the new chair of the National Assembly. And that's quite funny that we are still with the same type of people. And Isaac was very much involved in that, Isaac Franz, sorry, because we thought that it was a good opportunity to move ahead with rights for and from the citizen. But it didn't get to the end. Therefore, we have today a strange situation where a lot of new proposals for laws. When the COVID came, it was a long discussion about how we can use specific tools as Stop COVID, or now it's TOUS anti-COVID, all against COVID, and what was our right as a citizen, and what could be used. And there were different point of view from different bodies. The one in charge of the name French National Consultative Human Rights Commission, where, by the way, the chair, Nicolas Chagny and Lucien Castex are member on behalf of Isaac France, send a document saying that it's not the best way to be used. We get something about by the CNIL also and other bodies. But at the end, all that constitutional changes didn't get through in the last three presidents of the French Republic. What is important for us is that we need to find a way to have a better for the end user confidence of the use of internet. But it seems that it's more and more difficult to balance the right of the end user and the law, or the security, the public security, what the police wants, and what as the end user we want. That's some point I wanted to share with you, but I will be happy to answer any question if you have. Thank you.
Merci, Sébastien. Thank you. Thank you. just briefly, yesterday evening, I think, yeah, I was watching Macron address to the nation, and it was very all-encompassing, and I think everybody was feeling to learn from about new restriction, but it was very wide-ranging. And I noted that at one point he did mention the digital sovereignty. He mentioned that the upcoming French semester of the European Council. So I wonder, but then we will see in the discussion later, whether France in the upcoming semester will take the lead on this subject as well. If we will see Paris Declaration following up to the Lisbon one. And but thank you for sharing this experience with us. So I'll now pass to our Portuguese colleague Ana, who's very kind to share. Our experience is very fresh still. It's the experience with the presidency of the European Council in the past semester, where Portugal was, at the forefront of that with the Lisbon Declaration of Rights. But if you can tell us a bit more, just for people to learn, for those that are not into, following this debate closely, why Portugal decided to bring that at the European level attention, what were the hurdles, the problems, what was achieved, and what is the impact also at the national level with your declaration. So Anna, thank you. The floor is yours.
Thank you. So first of all, good morning, everyone. Thank you also to the Internet Governance for inviting me to be here. And I also would like to greet my panelist colleagues. So regarding the Lisbon Declaration, Digital Democracy with a Purpose, this declaration was launched, as Andrea was explaining, during the Portuguese presidency of the European Council on the 1st of June. And it took into consideration, and I think it's necessary to explain that this initiative took into consideration the communication from the European Commission regarding the Digital Compass, and it was also made having in mind the Berlin Declaration and the Tallinn Declaration that I believe Gemma will explain later on, but I didn't want to go on without it. What is important to know about the Lisbon Declaration, and I think before explaining, or maybe I should start by explaining why we came up with the idea. We felt that, as Laura was also explaining, as Laura was also telling you, human rights, it is necessary to reinforce that human rights that are applicable offline are also applicable online, especially in the digital context and with the pandemic and with everything going on with the world. We thought it was necessary to reinforce the application of those rights in the digital context on one hand. On the other hand, we thought that it was necessary to reinforce the European position in the digital as a digital sovereignty in the world. Currently, Europe is now facing a lot of competitiveness, especially with USA and China, and it is hard to compete with it. And we felt that Europe was seen and it's seen sometimes as an old continent. So what we thought was we could take advantage of the fact that in Europe, we respect certain values, certain principles, ethical and democratical principles and human rights here. So companies and countries and people who act here and do business in Europe respect those values and do business respecting it. And so it's the European way of doing business, as we said. On the other hand, and as I was explaining, to have additional sovereignty, it is not possible to be, Europe cannot be isolated from the world. So we needed to reinforce an international cooperation with other countries, like-minded countries that respect the same values and respect the same values and ethical principles. So that's why we came up with the Lisbon Declaration. And the Lisbon Declaration has these three dimensions: human rights, So it promotes human rights, ethical values, and democratic participation in the context of the digital area. It has an economic dimension where it promotes what I was telling you about, the European way of doing business as a world recognized, valued proposition that elevates standards by balancing technological development with the respect for ethical principles and human rights. And then it has an international cooperation where it promotes a multi-stakeholder and wider international cooperation in the digital ecosystem, while recognizing the importance of green and digital technologies. This declaration, and I think it's interesting because I was hearing Laura speaking about the Spanish charter, where it had a multi-stakeholder approach. The Lisbon Declaration also has that. So although it was built as an European perspective, it is now currently open for companies, non-profit, academic, and citizens to subscribe it. We already have the support of several technology companies that subscribe it, such as Microsoft, Amazon, Vodafone, etc., and citizens all around the world. So I would like to invite you all to subscribe it. And then on the other hand, it has, that I didn't explain you about, the Lisbon Declaration, it also has attached, and I believe that's the part that you want to hear more about, Andrea, an attachment of what we call a Charter of Digital Principles. So this charter had behind it the idea to reinforce the applicability of the rights, human rights in the digital context, and also to start a reflection about digital rights and to contribute to the European Commission that at the time was doing a public consultation on the 2030 Digital Compact. This attachment has only about 12 digital principles. They are all based on laws that were already applicable, the majority of it. So it's privacy, data protection and cybersecurity, intellectual property rights, internet neutrality, the use of artificial intelligence, freedom of expression and information, freedom of assembly and association, protection of children, and so on, digital education, public services, digital public services, and that's about it. So it is really shortened. We wanted to have a really short version of it so that it was easy, comprehensive, and easy to have in mind for everyone else. You were also asking me about the process, and this is a process, an European process. It's different than a national process, although it's hard also. As Sebastian, I was hearing Sebastian say that it was very hard to have the approval of the members of the parliament, to have the 27 members' approval of a declaration. It is extremely hard, I have to tell you. We started by the first draft of the Digital Principles Charter and of the Lisbon Declaration had a charter of digital human rights. And then while discussing it previously with the European Commission, we came to a conclusion that it should be digital principles and not a charter of digital rights. Not only because we already have a European Charter of Fundamental Rights, but because of the issues regarding it, the approval of it had to be different, and etc., etc. After having this previous negotiation with the European Commission, we started negotiation with the 27 member states. As you can imagine, it's hard. You get contributions from every member state, and all the member states are in different stages of their analysis of digital principles, of digital rights, and etc. So, like you were saying, Spain and France are in a very evolved stage, but there are countries that are in less. So it is very hard to accommodate their views on it. But it's worth it. We made it. We had a 27 member state subscription of the declaration, although not all of them subscribe the attachment that had the Charter of Digital Principles. What we learned from it, and what I especially learned during this procedure, is that if we could make it again, I would make it with even more time, to have time to negotiate with member states, and I would start with bilaterals with each member state to explain the purpose of it and the aim of it. I think it facilitates, it should make it more efficient and facilitates the whole process. The good news, as I was telling you in the beginning, is that the subscription is open. It's still open, so all of you that are hearing this can subscribe it. Other third countries can subscribe it, companies also, and the members, even the European member countries that did not subscribe the attachment can still subscribe it. So I invite you all to visit our website, that it's lisbondeclaration.European Union, and fill the form and read the full declaration and support it. Thank you.
Obrigado, Ana. Thank you. Thank you for taking us through your most recent experience. Lots of things to note from your experience with the initiative that Portugal brought at the European level. A lot of learning also from your experience of negotiating on rights. We all kind of know in the day to day that this is not any longer 1948. Getting consensus even on what was achieved in 1948 is not such a given, and our society got more complex, and more actors are needed at the table, and more actors on the table, more time to reach consensus, even on things that you thought were basic and fundamental as human rights online. And at this particular Italian AGF, we have a lot of schools that participate. So I really encourage the students participating, a lot of high schools, to go and read the declaration. I'll post the link for everyone to see, because I think this is something that it has to be studied at school. I'm not I'm out of school since many years now, but I certainly had to study the Italian Constitution, the European Charter of Fundamental Human Rights. I don't know if this makes into the school program, so I think this is an occasion to promote it. So now let's pass to Gemma, who I think has the hardest job of all, sitting in Brussels. I mean, it was just news of probably last week. Some of the member states that are not even respecting the basic fundamental rights, and they are risking to be kicked out from the European Union. So think about then going to the digital rights. But nonetheless, the European Union, as we all experience as European citizens with GDPR, it is at the forefront of promoting and protecting our rights, with initiatives that have an impact on everyone's life. So if you can, Gemma, introduce your in terms of the European Union, the European Commission work, moving from the declaration, the work in tandem also with the presidencies of the European Council, and to tell us what is the goal, what we want to reach in 2030. How rights are part of the next generation EU, or and we hear a lot about the DSA, we hear a lot about the digital sovereignty. We hear a lot about the need to getting a European cloud, but unfortunately we don't hear that much around our rights. And when it's about our rights, is always these rhetorics that the US innovate, the Chinese copy, and the European they just regulate. And that's the way that looks like the narrative is developing around the internet, but it's not complete the picture. So please tell us more about the European Commission lead in this case.
Thank you Andrea, buongiorno a tutti. Vorrei dire che sono molto lieta di partecipare a un evento di Internet Governance in Italia, anche se virtualmente in Italia dal mio ufficio di Bruxelles. So going back to English as this is the language of the session, I want to say that I am going to give you some information about this initiative we are developing, which is precisely framework for digital principles and rights. And but the first thing, considering the audience that you mentioned, that some of our participants, they are coming from the school, so from the I would say youngsters generation. So I think it's important, the best way to present why we did launch this initiative on a framework of digital principles is that because like one of the internet foundators we had at our events recently said, for the natives of the digital era, having an internet connection is like a refrigerator, and we take it for granted, and it's not even, we from my generation cannot even imagine what the digital natives can create. So besides this excess of regulation that some claim the European Union has, we are trying to create a framework for the next generation together with the next generation. So we are talking about Europe in 2030. So from here in 10 years, the so-called digital decade. Considering that the digital transformation is a fact, so digital is everywhere in our lives, and with what we have witnessed with the pandemics, basically, we have seen that we switched mostly online many of the even daily activities of our regular offline, from education to work life to shopping to communicating with anyone. And we also saw that there has been a huge increase in the digital divide, because in a situation where everything offline was kind of stopped, those who could not have a decent and affordable connection to the internet, they were struggling to have their regular routines ongoing. So this is really in non-commissioned words, the context into which the digital, the framework for the digital principles has been built. So we have issued in March last year this digital compass. What it is? It's a vision for 2030. And how it is, this vision is mostly a vision for a society where digital is basically ubiquitous, but where humans are leading this space, both in terms of their rights, both in terms of how the infrastructure is designed around the needs of the humans inhabiting this digital space, and also in a way where businesses of all size, in particular considering that in Europe we have the highest share of the market is of small and medium enterprises, where businesses of all sizes can innovate. So this is no news, the fact that we are trying to shape this sort of vision, in the sense that the speakers who were before me, they presented several national initiatives, and Anna was mentioning, so at the level of the European Council, we had the Tallinn Declaration, Berlin Declaration, the Lisbon Declaration. So basically, almost every other European Council configuration has put the finger on the fact that we need to have a vision for the digital transformation, which starts from the people. So this is, I would say, a clear trend. Even recently, the European Parliament put the finger on the need for digital transformation to be above all inclusive, so where everybody can take part of. So the digital compass, what I was saying, our vision for 2030 is trying to put some targets, so where we want to go in some specific areas, and these are areas that really impact everybody. So we are talking about digital skills, because there is no access to technology if you don't know how to use it, in particular advanced technology. We are in the era of artificial intelligence. And then you have digital infrastructures which need to be adequate and support not only connectivity but be shaped in a way which is coherent with what also Anna mentioned, the European way of doing things. So this needs to be inclusive, sustainable. They need to ensure the respect for the privacy of the people. So everything which we call very proudly, I would say, the European way of doing things, which we don't think is nothing less, perhaps a lot more than what is done elsewhere in the world. And then we have two other parts which are very significant. First, for the citizens, so the public services, the strong need for modernization of public services to ensure that they are up to the standards of the digital transformation, and of course, the digital transformation of the businesses. And this is, I already mentioned before, the SMEs. So once we set out these targets for this area, and we say this is how we see the European Union in 2030, we say this needs to be complemented by a framework of principles and rights. I will use the two words in parallel because, of course, rights are mostly established in law. And what we are going to do with the Declaration on the Digital Principles and Rights, we will refer to existing rights in law, but with the principles we go a bit further. So we say how we want to inform the action of the policymakers in the next 10 years, including actually mostly starting from the EU institutions who will commit to this, and then seeking broader subscription, and also to make sure from the side of the users, businesses, but mostly the citizens, that they are aware. Because, you know, what we have done, and this is again a common trend, because you cannot speak about rights without involving those who are who hold these rights. So also in our case, this is a very participative process. What we heard is that, for example, in the Eurobarometer, which surveys specifically the citizens and is going to be released soon, so I'm giving you a bit an anticipation, so that there is a huge percentage, like 70% or more, of people who reply they would like to know more about their rights in the digital sphere, because they don't feel they are sufficiently aware about it. So this is the balance between the principles and the rights. So what we have done, we launched a public consultation where we presented the specific areas that we think need to be covered in this set of principles and rights, and they are, I would say, quite covering quite a broad range of areas. So we are talking about access to internet, which appears to be still a huge area of interest. Actually, we got from the public consultation like 80% of respondents saying this is the top priority. So have adequate access to affordable internet connection. We have areas related to the most important services, for example, digital health services. We have the European digital identity, which is considered as an enabler to basically enjoy the rights in the digital sphere. But we also go a bit further on some more technical aspects. So the need that the algorithms that underpin mostly of the activities online, they need to be based on ethical principles. And then we have, of course, as I said before, principles around the digital public services administration, how they should be accessible and based on the needs of the people. and specifically also focus on the protection and empowerment of children and youngsters in the online space. So we had the preliminary collection from our studies and also taking into account the experience at national level, some of which have been presented, and we put them to the public through public consultation. As I said, also Eurobarometer, so surveying directly the citizens. We organized also, I must say, quite a few events and collected feedback. Now we are really at the final stage of this process. So actually, if this event would have been a bit later, I could come with the final product. But we are at the very end of this process, because having held this important consultation process, the Commission is finalizing what is called the Declaration on the Digital Principles and Rights. And we aim to adopt it by the end of the year, so basically before the end of next month, and then propose it to the European Parliament and the Council for a signature, so that this would be joined. So all the institutions join forces in this process. I would like to say a very last word on the fact that what you say, that there is a path. There is a path, not only because this is a topic which over the years has been of great importance for the European Council and the member states, but because we did a check about what sort of initiatives are present that are kind of mirroring what we are doing. And we have found at least 30 both at the national level, at international level, at also non-governmental initiatives. This means that there is a real need for this. And let me also recall the initiative from Italy from 2015 on the internet bill. If I'm not mistaken, was the internet bill that that was not mentioned until now. So there is a clear need to put a bit on paper what are the digital principles and rights governing the transformation we're witnessing. So back to you, Andrea, and happy to contribute further.
Thank you, Gemma. Grazie, Gemma. Thank you all. It's been, lots of information shared, lots of good points made, and ideas that were shared. And now, I would like to first see if there are any questions. Open the floor to the rest of the audience. I know that we are in webinar mode, so the chat is not open for everyone, but you can also use the Q&A pod. I'll switch in Italian. Se volete fare delle domande potete alzare la mano. Non so se posso darvi il microfono perché siamo nel sistema webinar, però potete scriverle nel box di Q&A, di domande lì. So let me switch back to English in the meantime if I see any questions or hand raised. I really like, of course, I like this subject, and it's a subject that keeps me busy thinking every time that I read an article, that I download a new app, that I read some shocking, not that shocking news, and I reflect how this debate, although central, gets sometimes lost into the old noise. So, for instance, I was mentioning, I don't know how many of you heard the presentation about the metaverse and how Facebook, former now Meta, is already designing what the internet will look like. So I tortured myself when I went and I saw the whole hour and a half presentation that Mark Zuckerberg made about this metaverse. And one thing that struck me was not only there was no mention of rights, but it was this mention of experience. And I think he mentioned experience probably 2,000 times during the 1 hour and a half. And but it is is a trend that we saw. It basically, we know that when you don't pay a service, you are the product. We know that, and we know that the evolution of that is that our experiences, our daily lives, are being part of the product. So they're being monetized and we're being sold. No, and the metaverse is all about that, from what I understood. But of course, experiences are based on our physical daily lives, our relationships, and our fundamental rights. So I see that there is this trend. I don't know how much we can stop it, if we can stop it, of basically. So let me just close the thread of commercialization of our rights. You know, and we saw what happened with privacy, and privacy. You know, it took probably 15 years to realize that our privacy was infringed every time that we downloaded an app, we signed up for a product. We didn't know that this product was using our data to sell us or push us other products and advertisement. And there is always this catch up. So my question to you is, whether you think that we will always catch up. No, we will always be behind. And yes, it's good to put these rights, but it's not enough. And having those, it's a step, but certainly won't stop this trend. So first, my question to you, if you share that assessment, it's more like it's my assessment as a user. And then if you in this case of Laura and probably Anna, if in your experience of having national charters, I can tell you later about the Italian charter, for instance, if you see already some impact, if you see, local courts referring to this charter, if you see judges looking for indication from the policymakers, from the legislators about the need to, implement those rights. And, the pandemic brought us everybody online. We are working in this environment. I'm just thinking about now, the labor rights and all how this has to be readapted and translated into this new environment. Did you see that, your experience in your own country, this is specific for Anna and Laura, had an impact on that already on the day-to-day life? And then, on the first question, do you think is that enough? Is that the way to go? Or we will always catch up with, the innovation, or, the move fast and break things still is the basic principle of the internet development. So who wants to go first? Just open the floor. You can choose one of the two.
So I don't know if I can take the floor.
You did.
Okay. No, I don't know if Anna would like to go first. Otherwise, okay. So I open the debate in this sense. Well, I share your point of view, Andrea, because I don't know. I didn't say that, but in our unit we deal not only with digital rights, but also with the regulation of digital society as a whole. So we are dealing with dossiers such as the DSA or the Digital Data Act or e-privacy. So we've seen in the past that regulation is always behind the reality. So we are always catching up or trying to catch up. And to fill this gap between regulation and reality. I am a lawyer as education, and it's not something new in the digital environment. We always regulate realities that already exist. So this was already existing in the offline life. The fact, the difference I see is that now these changes are occurring, faster, and it is becoming very hard for the regulator to catch up and to fill the gap. As regards our experience and the impact of the work we've done at the national level, at least here in Spain. Well, it's very new, so I cannot present you balance, but we think that there was a need felt from the citizenship, because we received a lot of contributions during the 2 open consultations that we carried out. So we think that there is a need. There is a path followed by countries or international or EU institutions, and there is a need felt by citizens to protect their rights in the internet. We know that our text is an umbrella, and as such requires the intervention of different policymakers, such as state regulators, and in Spain, regional regulators, and then other sectors or organizations. So we know that we have a lot of work to do, but we think that this chart can be a reference and can be a set of principles informing our action and our policies in this field. So just give us some time to present you a more, I don't know, complete balance. But I think that such actions are important since they come to complete the work of other institutions, such as the EU or other countries. Thank you.
Thank you, Laura. And I can jump in here, and then I'll pass to Anna. To just give you an example, so we didn't speak about the Italian Charter of Italian Bill of Rights and the whole experience of 2015. I think it's interesting even to share why. This is a 2015 initiative, and in the preparation of this panel, I went and looked for those that participated in this experience, and none of them is in the current parliament, and the experts, they moved on. And so I had this feeling that, okay, this was a good initiative, a good experience, 2015, but it didn't leave really a trace. But then, I kind of stopped and I said, actually, wait, that's not true at all. I think during the last government, Italy was one of the few countries in Europe that had a law on revenge porn, and which is a heinous, horrible, practice that impacts a lot all of basic human rights, privacy, dignity, and particularly is targeted not only but mainly to youngsters, to young people. So the debate for the discussion and the approval of this law, it actually referenced the Internet Bill of Rights Charter. So there was an impact that, at one point I was like, okay, this thing is gone. We need to. It trickled into the the society. The society was ready for that, and it trickled also into the policymakers. It could do way more. It could do way more. There is a lot of there was just recently a debate about approving a law on discrimination on LGBTQ community in Italy, which also had a component on the online world of labeling people, in a pejorative way due to their sexual orientation. It didn't pass, and so it's not always a win. But indeed, the charter brought the global attention, and another thing that I noticed is that as it was a charter, and for many policymakers was like, what, this is a charter, it's not a big compromise for us, so we will endorse it. And indeed, it was endorsed by the full parliament. There was no opposition to the charter, which back then seemed an easy thing. But indeed, it kind of implies a commitment for all those parties. You know, you submitted that, you thought it was only a charter, and then it also played in the approval of this specific law. So it's you don't always see the direct impact, but is indeed an impact. But it's unfortunate that we couldn't get participants for this panel on the experience of the charter. And as member of the Italian IGF, the goal of this session is also to reawake this initiative and to bring the Italian community and the current policymakers' attention to that. But indeed, I think, and I personally share the view that it has to be at least a European-wide initiative. It has to be. That's my firm belief. It has to be at the level of the European Charter of Fundamental Human Rights. Because if one thing we learn about cyberspace is that borders, they have no real meaning anymore. And so, indeed, these rights has to be protected at the widest geographic level possible in the cyberspace. It makes even more sense. So that's just to mention the Italian experience. But Anna, let us know what you think. Is that enough? Does it work? And we will always catch up.
So first of all, let me tell you that on the first draft of the Portuguese Charter of Fundamental Digital Rights, there was a reference to the Internet bill, the Italian Internet Bill of Rights. So it was used for our first draft. So it came really helpful, and so it's not forgotten. At least in Europe, it's not forgotten. Regarding your question, so as Lara was saying, I'm also a lawyer, so I see this not only on the digital environment, but outside of it. It is really hard for the law to catch up with what is happening at the moment. So this is something that happens in all of the sectors and in all of areas. I'm not sure if there is a solution for it. I was just thinking about it. Maybe we should have principles of what to govern the actions of it, because it's hard. Like Laura was saying, the technology evolves in such a fast way that it's almost impossible to catch up even for us. And so perhaps the best way to do it is actually to have a charter that regulates the principles that should be applicable to all the technologies. Although every time that a new technology will evolve or will appear, other problems will for sure appear. So it is hard, and I'm not sure if we'll ever find a solution for this problem. Regarding the impact, or concerning the impact of our national charter of digital rights. So it is also really soon to tell, because our charter was approved in May 27. However, I can already tell you that we felt already some implications. So our charter has mandatory actions for the government. So one of them is the creation of an internet social tariff, so that people who cannot afford to have internet for a small price. And that is already being implemented currently. So that's an implication from the charter. It has also implications regarding digital education and digital public services, and that we are already also seeing on it, not only because of the charter, of course, also because of the pandemic, but it turns out that it's written on the charter and it's being currently applicable. So we can also see that currently. I cannot tell you about court decisions and etc., because it's really soon to tell. Maybe next year we will be able to gather all of that information, but we can see already those implications. We can also see that it turns out we started debate about it in the Portuguese society. So there was a lot of talk that it's still going on about it. So it raises people's concern about it. So that was, and it started a debate. That was one of the goals of the charter. So that had a huge impact on it here in Portugal.
Thank you, Ana. Obrigado. Thank you. That's very interesting. About the, for instance, subsidizing internet access. This is something that, it's once you have it in a charter, then it's a tax that we will all pay to get everybody an online connection on a digital presence, so to fulfill their rights. So this is I think a clear example that basic fundamental rights to be implemented and protected, they need to be also economically supported. So that's the same principle that that makes public school free for everyone. So that's important to see. It's a very good experience. Thank you for sharing. Okay, Sébastien, I have a question for you, and since I know that you don't represent the government, but you are a member of the Internet Governance Forum France. Well, you will have, I think is at the end of the month, you will have your Internet Governance Forum, and you will have the government represented, and France will have the semester presidency of the European Union. And tell us more if you heard something, or do you think if ISOP will push for that, and you will already take advantage in the upcoming French IGF of renewing the discussion about the basic rights. I mean, as I said yesterday, I heard Macron, he spoke about we won't succumb to the internet giants, and he presented the way in a very kind of controversial, like warlike scenario. We have to defend our territory from the invasion of the internet giants. Will there be more than that? Will we hear, do you think? Or if not, do you think the French IGF will be able to re-push the initiative on basic fundamental rights? And second question, if you don't think that is enough, will there be another initiative at that level? Was it too high to get digital rights in the constitution? I know that France had a similar experience for the environment and protecting the environment and the public consultation, and so changing the constitution to include the protection of the environment in the constitution. That kind of went through, but not the digital rights. It's too high. Shall you scale back and just work on a charter and see how it trickles down? Or I think that's the only way to go.
Thank you, Andrea, for your question. I will start by the second. And everybody talk about environment, but very few people talk about digital in general. It's of course something we talk, but we talk about the product, not about the governance of this. If I can take an image, we have a Green Party. We don't have a Pirate Party in France. It's a big difference. Green Party push to have this environment included in every discussion, but not the digital. Therefore, it must go to it must be the role of organization like Internet Society. But what it's the big trouble we have, it's that yes, France will be sharing the European Union for the first 6 months, but at the same time, France is going through elections. the presidential election in April, and in June the parliament election, and therefore you don't know when any politician talk today, if they talk because they are in charge of Europe or because they are in charge of being re-elected. And it's a big difficulty we have to face. I am not sure that the best way for Europe to be in the end of a country where we are going. The only thing important will be re-election. Therefore, everything will be done to be re-elected. And I am not sure that it's good. That's my personal point of view, of course, good for democracy and good for Europe. In the same time, I wanted to add one point. I hear a lot, and it's normal where everybody is coming from about regulation. But sorry, we are in a IGF, Italian IGF. It's a multi-stakeholder body. It's a multi-stakeholder arena. If we are at the end just trying to do regulation, why we are here? Government are elected and can do whatever they want. They consider they can regulate what they want. But we are pushing for multi-stakeholder engagement and activities. And my last point, to be not too long, is that if you consider that in each country we can solve something who is worldwide, we are all wrong. Google, Facebook, whatever new name, Meta, whatever they want, and Amazon and so on and so forth, are a worldwide organization, even if they are based all in United States. And it's if we don't find a way to struggle with them or to push them in one direction at the worldwide level, nothing will happen. It's not because we have a law in our country that it will change the way each of those organizations will manage what they want to do. They will find, even if they are, if we tell them not to do something, they will do it in another way. In the same time, I wanted just to tell you that my impression about Facebook or Meta verse today, it wasn't something called Second Life a long time ago. Okay, I am maybe a little bit too old here, but we already faced that at the beginning of internet. Internet was not one single network. We had to choose between the CompuServe, AOL, Microsoft, and so on and so forth. And I have the impression that we are redoing the history, and I hope that we will not go in that direction, and we will keep one single open internet. Thank you.
Merci, Sébastien. Thank you. I certainly do remember Second Life, so it makes me also kind of back from the internet 1.0, so kind of conceal my age. Let me see if there are questions from the floor. I saw a hand coming up. So se ci sono domande, potete usare provare a intervenire direttamente o scrivere nel QA pod. Forse ne vedo una nel QA pod. Allora, no, open, dismissed. Ok, no, non vedo domande. Chiedo alla regia se chi vuol fare una domanda può aprire il microfono e intervenire direttamente, o devo dargli un ok io. Ok, per adesso. Ok, allora la regia abiliterà il microfono. Okay, so this is the webinar model, so it's a bit more different to see who's intervening, who wants to raise hand. Okay, so I'll continue just asking questions to you, and I want to ask a question to Gemma, but also everyone can intervene. Clearly, we saw that the digital, no, the GDPR, was the the most impactful initiative to protect and to reframe our privacy online. And we're looking forward to the DSA as well. And but still, from your experience, Gemma, do you think that overall encompassing, initiative like the declaration to have a European Charter of Digital Rights, are those two parallel tracks? Meaning, we'll get into subsequent regulations of specific sectors, privacy, and then platforms, and then digital markets, and then security, and then parallel with that, we will have, a process that will lead us to a consensus on digital rights. Or maybe we should start the other way around. We should get the digital rights side first, and then, regulation will come from that. What do you think? And what's actually, your assessment, and what's the line now with the Commission?
So thank you, Andrea. I think, when you mentioned GDPR, you mentioned something which is for everybody a cornerstone of the protection of personal data. This is something which is, not liked everywhere in the world, but at the same time, it's something which protects our citizens, no matter where. And also it's becoming a source of inspiration for other legal frameworks around the world. But we have, in general, in the digital sphere, we start at least having a pretty advanced framework as regards regulation, because we have the GDPR, we have a very advanced now framework on cybersecurity. We're from the NIS directive, now the review of the NIS directive, Cybersecurity Act. Then we have, in terms of regulation of platforms, now we have two important acts on the table, the Digital Services Act, the Digital Markets Act. We have the new proposal for the regulation on artificial intelligence, and there is really an awful lot of things going on the regulatory sphere. But I think it's very important what Sebastian said. So we cannot just keep regulating and everything will be solved. So the idea of having a framework of digital principles is just not like to have the green badge or a medal that we are also following that aspect. Is really the idea to have a set of principles that would encompass all areas of digital, a sort of umbrella. Because first of all, many areas are linked, as I mentioned before. Like you can speak about the skills, but you can also speak about being skilled enough in advanced technologies. And then again, it's linked to the debate on the fact that artificial intelligence needs to be based on algorithms that are ethical and so on and so forth. So everything is kind of connected in a way, but also because you cannot get everything through law. First of all, there is an important part, which is the ability of having the tools to exercise the rights. And these tools come mostly from innovation. So we set the principle that, for example, privacy needs to be by design, so that everything that is developed in terms of digital products and services needs to be privacy preserving. But then, you need to have the innovators, the companies, the startups working on it. And they are those who in the end come up with most likely the right solution beyond what is the regulatory framework. Then you need to have the participation, of course, of the civil society to make sure that there is a right level of awareness also among the citizens. And this is what you said, these are things that needs to be studied at school about what are the rights, but also what type of digital transformations the political level committed to, because the political level needs to be constantly reminded about what what they committed to do and how in particular. So there is of course the essential component of the research, because we, as I think both Laura and Anna mentioned, we try always to catch up and we are always late. I mean, it's the way the digital transformation is shaped is a lot in the hands of the research, and also many of the solutions to problem we don't even know they are coming are really we can get there through the help of the research, the academia, and so on. So it is indeed the idea of principles and rights for the digital sphere. It is really something which comes on top. It comes on top not because it's an add-on, but because it's an umbrella. And then everything which is sectorial or horizontal, even in terms both of regulation or funding, which is yet another instrument which is used a lot by governments and at the EU and also national level, they need to basically be informed by these principles. So I think it is not only a horizontal topic, but something which needs to cover all the policies. So
Grazie, Gemma. Thank you. That's clear. I share the view, and I also, I also think that there is this part of financing and supporting, as we saw with Anna, which is a part important of also enforcing the rights. I see there are 2 questions in the pod, and I don't know if there is the possibility for attendees to ask the question themselves. La regia e chi ha fatto le domande può solo scriverle o può anche leggerle? O le leggo io?
E abilitiamo subito l'audio della persona che ha posto la domanda.
Perfetto. Allora vedo prima Francesca Papasidero. Francesca, audio, microfono spento. Vediamo un po' se...
Audio è attivo.
Però vedo che il microfono di Francesca
è disabilitato, sì.
Disabilitato. Quindi il diritto alla libertà di espressione di Francesca noi l'abbiamo già disabilitato così. Francesca, riesci a accendere il microfono? Voi da regia riuscite ad aprirglielo, ad attivarlo? No.
E il microfono è attivo, forse conviene leggere il messaggio, la domanda.
Ok, comunque la domanda la possiamo leggere, la leggo in italiano, poi la traduco in inglese. Lei pensa che la digitalizzazione e l'introduzione di internet sia pienamente compatibile con il rispetto della privacy e dei dati sensibili delle persone? In inglese, do you think that the digitalization and introduction of the internet is compatible fully with respect of privacy and personal data? Chi vuole rispondere a questa domanda? Who wants to address this one?
Can you repeat again, Andrea?
Yes. Do you think that digitalization and introduction of the internet are compatible fully with respect of privacy and personal data of people? It's a general question. It's basic, and I have my answer to that, but I don't want to jump in as a moderator. So if any one of you wants to address this one. Otherwise, I'll pick one of you.
I'm not sure if I fully understand the question, but if the internet and digitalization are fully compliant with privacy and data protection.
Yeah, I think the question is kind of fundamental. It's whether the internet in itself is compatible with respect of privacy. And my direct answer is unfortunately not. but that's I think it's a basic and critical question of of the design of the internet, or the design of the application. But I don't want to jump in with the answer. I just wanted to.
That was what Gemma was saying about privacy by design and by default, that the internet was not built upon it. I think, on general, it's very hard to be totally how can I say this? It's very hard to be totally compliant with data protection and privacy laws. But for new products, it's easier. And for terminal companies, it's easier because the GDPR and the privacy laws are really strict. But the internet, as we were saying, was not built upon it. So I think it's starting to respect more and more privacy and data protection rules. And we can see that big social medias and search engines are starting more and more to fulfill with it, to comply with it, but it's not still 100%. They are not still 100% compliant. Hopefully one day they'll get there.
One day, I agree, and I also realize that we are already 1 minute past the end of the session. So if the organizer just allow us to keep a couple of minutes more, just to give like the final words from you, and also my final thanks. I see there is another question from Irene. What do you think about Italy? That is the only country without a lawful LGBT community, and yes, there is an issue. It's but it's not completely for this panel to address. Although, as I mentioned, Italy, could refer back to the charter, to the Internet Bill of Rights, and I'll really push for. All those interested in going back to the charter and then trying within your engagement in Italian IGF to bring it back to life. But last concluding words from any one of you, Gemma, Sebastian, Laura, Anna, and before I just conclude with my thanks, anything that you want to add from this discussion, for your experience, for what you look ahead, and if we will have this session at the next Italian IGF, do you think that we will have a European charter? Maybe not yet. A French charter depends on the election. Spanish and Portuguese, we already have them. But what happens with the rest of the European countries? And we will be having this session in the metaverse, or in Second Life, or in real life. Ever again. So this is another interesting point. So any other final remarks you want to share?
Andrea, just allow me to thank you and thanks everybody for this interesting discussion. I do think that in 1 year we'll have the declaration adopted. Let's see whether we'll have a full charter, but for sure I think we can have such a discussion again, because in the context of internet governance, as Sebastian said, it's not by chance that we are having a discussion like this at an IGF, because there is indeed in both components, so the preparation for digital rights and internet governance in general, the huge multi-stakeholder components, and therefore the need to have everybody on board to make sure that if we have such principles, then we implement them. Thank you again from my side.
Thank you, Gemma. Okay. Thank you all. Anna, do you want to say just final word?
Yeah, no, just to say thank you also, and hopefully, I hope that this discussion raised the matter once again of digital rights. And I also believe that next year we can still have this discussion, but we will have more intel on the implications of the national charters that were adopted. I am an optimist, so I believe we will have an European Charter next year, besides the declaration that we will have this year. So I think next year we can have full discussion on it. And I think this will stay, unfortunately, on the horizon for several more years, as well as the European Union Charter of Fundamental Rights is still discussed today. I wish it was not, because it meant all the rights were respected, and so it was not necessary to talk about it. But I think we will be talking about it for a very long time.
Indeed,
So
Anna,
thank
you
you.
cannot take rights for granted once we're put in a charter, even if it was more than 60 years ago. And so even more important is to have the discussion on the evolution of those rights in the digital space, as the digital space becomes more and more prominent on our daily lives, and probably won't be any distinction anymore. We will be, call it metaverse or whatever, we'll be having, connected devices, we will be on 24/7, and even once we are no longer on this earth, probably our digital footprints will be continue being living in the cyberspace, and so there is a lot of discussion, and I think also in the doctrine has to be addressed. That thank you all, obrigado Anna, grazie Laura, merci Sebastian, grazie Gemma. Spero che nella prossima volta ci potremo vedere in persona al DGF senza dover fare queste cose su questi piccoli cosini di Zoom. Grazie a tutti, grazie ancora, a presto. Be safe,
Grazie mille, Andrea.
online and offline.
Thank you.
Grazie.
Grazie.
Arrivederci, grazie.
Arrivederci.